Hey guys, welcome back to my channel. Today I'm starting a new series on my channel called Lux Law, and I plan on talking about lawsuits from major luxury brands that you might not have heard of. Many luxury companies have entire teams of lawyers that go after counterfeiters, and it's really to protect the brand and the image of the company. Now, with a lot of these counterfeiting claims, they refer to the Lanham Act. The Lanham Act was passed in 1946. The Lanham Act protects against trademark infringement, trademark dilution, basically copyright infringement. And I will link everything below. All this information is publicly available. The first case you might have heard about, and it involves Dooney Bourke. In October 2002, Louis Vuitton held its fall 2003 fashion show. And that's where they first debuted the new multicolored design, which we all know and love. It basically consisted of the same Louis Vuitton monogram pattern set on top of a white or a black background. And this was in collaboration with a Japanese artist, Murakami. There was such a huge interest for that design that there were waiting lists going into 2003, 2004. So when Louis Vuitton saw that there was an interest, they went ahead and decided to make it part of their permanent collection. And it kind of inspired many other designers to come out with their own version of a brightly colored, multicolored logo against either a solid white background or a solid black. And one of them that was well known was Dooney Bourke. Now, Dooney Bourke, they also had a line of bags known as the Signature Collection that started in 2001. Well, in 2003, they introduced a new line of It bags, which featured the same Dooney Bourke monogram, but also set on a white or black background. So true to Louis Vuitton fashion, Louis Vuitton sued Dooney Bourke. So in 2004, Louis Vuitton filed a complaint alleging trademark infringement under the Lanham Act. They also alleged unfair competition and false designation, claiming trademark dilution of their own brand due to Dooney Bourke's multicolored design. So in civil court, when a plaintiff is suing a defendant, the plaintiff basically writes up a complaint and they kind of enumerate everything that they claim the defendant is violating. Dooney Bourke got this complaint and they responded with a request for a motion for summary judgment. And that's when they respond to every allegation, say why they are not wrong, and then they ask the judge to basically make a ruling of the case before it even goes to court. Dooney Bourke moved for summary judgment, and in 2008 the judge ruled in their favor with the following holding. They said the similarity of marks was unlikely to confuse ordinary consumers, that there was no actual confusion between the products, that the competitor did not act in bad faith using allegedly infringing multicolored monogram on the handbag, that Dooney Bourke's use of the multicolored monogram on handbags did not actually dilute the mark of Louis Vuitton. So the judge ruled in favor of Dooney Bourke. Another case is Louis Vuitton versus Diggity Dog, LLC. If you've ever shopped at Saks off Fifth, that's their outlet version of Saks Fifth Avenue. And I have seen this myself. I never got it because I don't own any pets, but there was the cutest line of dog toys, and it was called like Louis Vuitton dog toy, and it looked like it had the similar Louis Vuitton damier checker pattern, and it also kind of looked like the Louis Vuitton monogram, but it was as a dog toy, so it looked like little handbags, but they were little chew toys for dogs. True to protecting their brand, Louis Vuitton went ahead and filed a complaint against this company, Diggity Dog, LLC. And by the way, they also make, fake Birkins that they call Barkin. It's just so cute. Louis Vuitton filed a complaint alleging that the Diggity Dog's marketing and sale of its Louis Vuitton dog toys infringed on its trademarks because the advertising and sale of the Louis Vuitton dog toy is likely to cause confusion. Similar to Dooney Bourke, Diggity Dog filed a motion for summary judgment, and the judge ruled in the defendant's favor, granted summary judgment to the toy maker. Louis Vuitton appealed, and so when it went to the appellate court, the judge held the following. The Louis Vuitton dog toy was a successful parody of the Louis Vuitton bags. The appellate judge also held that the toy maker's marketing, sale, and distribution of the alleged infringing toy was not likely to cause confusion, which is required to establish trademark infringement. And also, the toy maker's use as parody of certain altered elements of the manufacturer's copyrighted multicolored design did not support a claim for copyright infringement. So the appellate judge affirmed the lower court's decision to grant motion for summary judgment to the defendant, and Louis Vuitton lost once again on their claim. Because under the Lanham Act, there are some exceptions, and one of them is parody, which is what the toy maker did. If you have seen the movie The Hangover II, you may have noticed that there was a fake Louis Vuitton bag in one of the scenes. So in the summer of 2011, Hangover II was released, and it was a sequel to their 2009 movie, The Hangover. So in the movie, they're flying to Thailand, and Alan, who is played by Zach Galifianakis, has a bunch of luggage, and they kind of appear to look like Louis Vuitton, but they're not, because it's this Dior brand. This is a brand that you may have seen maybe in Chinatown. It's kind of like a designer-inspired bag. It's a bag that's kind of inspired by the Louis Vuitton monogram. So the bag that the character was holding in the movie wasn't a Louis Vuitton bag, and it wasn't a fake Louis Vuitton bag. It was this brand Dior, which maybe kind of looked similar in the design, but it didn't bear the Louis Vuitton logo, and it wasn't a counterfeit bag. Zach Galifianakis' character carrying a keep-all, or what was supposed to be kind of like a luggage. But at one point he even says, and this was quoted in the complaint, he says, "Careful, that is a Louis Vuitton." Well, Louis Vuitton sued. So they sued Warner Brothers, which was the Warner Brothers Entertainment, for this fake bag, alleging that use of the third-party knockoff travel bag infringed on its trademarks. Warner Brothers filed a motion to dismiss, which is different from a motion for summary judgment. The judge held that the use of the knockoff bag did not infringe on Louis Vuitton's trademark under the Lanham Act, and also that the use of the knockoff bag did not violate New York's anti-dilution statute or amount to unfair competition. Basically, that reasonable viewer of Hangover 2 would not look at that bag and say, wow, my respect and my view of Louis Vuitton has been tarnished. So Louis Vuitton once again lost. But kudos to them for trying to protect their brand. So those are just a few examples of cases that I plan on kind of diving into. Those are just some examples of cases that Louis Vuitton lost. Now, of course, there were many cases where Louis Vuitton has prevailed, especially against counterfeiting. I also plan on talking about other companies. Hermes has a couple interesting cases. Christian Louboutin that was another notorious case against, I believe it was YSL, trademark red bottom soles of their shoes. So yeah, this is just an interesting kind of facet of the law. If you're also interested in finding out more about what goes on in the courtrooms with these brands, definitely subscribe to my channel. Let me know what brands you're interested in hearing about, and I will definitely get back to you on that because there are so many. I hope you found this interesting. I hope you stick around for more, and I hope to catch you in my next video. Bye.